We're very proud in Washington State of our extremely innovative tech sector. We want to make sure that the economic benefits of our digital economy continue to come to the United States and benefit the United States. We also want to make sure that we are protecting the global, national, and domestic security and protecting our civil liberties and privacy rights of U.S. citizens. And I agree with our ranking member when he said at the very beginning that we do need to make sure that we get our details right. Mr. Downing, I wanted to just follow up on Mr. Raskin's question about what constitutes serious crimes, because obviously public discussion is centered around investigations into serious crimes. I know Mr. McGinnis defined it as anything that gives you 3 years or more, but can you give me a little bit more detail in terms of how we would assess what is truly a serious crimes, and would these agreements also apply to less specific national security threats? And with regard to the serious crimes, because of the way our justice system works, we have a lot of mandatory minimums, we have other things that put certain crimes into a framework that may not comport with the United Kingdom. Can you just give a little bit of insight into that?
So we were choosing the framing of serious crime in order to provide at least a little bit of flexibility, as different countries, as you correctly point out, have slightly different approaches to sentencing in their different countries, and what might constitute a particularly severe sentence in the UK may not be quite regarded in the same way. I would see, for our law, it would be, felony crimes would be probably a rough and ready way of looking at it. But the reason we didn't try to specify it with even greater specificity in the proposed framework is that there may be a need for some flexibility. With respect to national security threats, I want to be clear, this is not an intelligence gathering tool. The agreement is aimed at the investigation and prevention of crime. Of course, there are some national security threats, such as terrorist threats, that also are crimes and so would be covered here. But it's not intended as a sort of counterintelligence or other national security work. It's a provision oriented towards solving and preventing crime.
That's helpful, thank you. And in the proposed legislation from the department, you talk about orders issued by a foreign government must be subject to review or oversight. Can you clarify exactly what you mean by oversight? What would Congress's role be in that? How do you foresee Congress having that very active role in oversight that I believe we should have?
So I think the provision that you're referring to talks about the oversight of legal process that's issued within one of the two parties. That is, when the British police officer is investigating an organized crime group, there needs to be oversight of the application for that court order. A slightly different question, I think, is what Congress's role in overseeing this entire process of developing a framework and an agreement. And as I've said, I think it's our expectation is that there will be close collaboration with Congress. We've certainly worked hard over the last year to try to be involved with committee staff, on both sides of the House and the Senate. We also see a strong congressional role in setting up this whole framework. It's very much a congressional choice to be able to figure out what the rules ought to be for these agreements going forward. And then there would be notice to Congress before any agreement goes into effect to make sure that Congress has a role at that stage as well.
And so you would be willing to subject these agreements to a vote by Congress?
So the proposal doesn't formally create a requirement that there be a vote by Congress. This is more like, I suppose...
Would you be willing to agree to that, though?
I'm not sure what you mean, a vote by Congress. I think Congress is, of course, always able to pass a law that would block this kind of thing. So it doesn't need to be said, I suppose, if you like, that Congress has that authority to do so.
Thank you. Mr. McGinnis, one of the chief concerns underlying this discussion has been the move towards data localization. And I know my time has expired, but if you could just quickly say, economically and politically, what are some of the harms of data localization laws?
So the United Kingdom, Her Majesty's government is opposed to data localization. And we're opposed to it because we think it undoes the good that has been done economically and in terms of our ability, frankly, to live our lives that we get from network systems that are agnostic about where data is and where it goes. So we're opposed to it. We see data localization as, and the companies are better to speak to this, and I think you have colleagues from Google coming afterwards, but we see it as, frankly, slowing down the functioning of the internet in itself, but also perhaps technically, but also, frankly, potentially limiting the value of commerce through the internet. And also, frankly, it's going to lead to many more difficulties about ownership of data and the working system. So we're opposed to it. It's a matter of policy.